right, here we go. Hey, good afternoon, everybody. My name is Anna Cunha, Angus and Terry. I think see a lot of familiar faces. Most of you I know, but if you are new, our firm does a lot of work with your accounts, and we've been around for over years. We do both general counsel work and construction defects. So please feel free to reach out if you have matters that need assistance in those two areas. Today, the topic for today's discussion is basically the Open Meeting Act, but mainly what you need to know to help you facilitate effective and efficient board meetings. Because one of the most important parts of your job as managing associations is helping notice meetings, run meetings, and then prepare meeting minutes after. And then, it's a big part of making sure that the corporation is operating, is having these meetings. So we'll just, for a lot of you, this is just back to basics. Hope, a refresher. So starting with the Open Meeting Act. So for those that are new, the Open Meeting Act, you'll hear about it all the time. It's a lot of the reason we do what we do, why we notice meetings, why we have to have an agenda, why only certain things can be discussed in executive session. So if you wanted to read the code, this is probably one of the most important ones to read. This portion of the California Civil Code 4900 to 4955 is what we call the Open Meeting Act. Other nonprofits have similar types of code sections that guide their meetings, like the Brown Act, which basically these are the laws in place to protect transparency and allow members to observe business being conducted. So even though they can't necessarily participate and make decisions and vote at these board meetings, generally members have the right to know what's going on and to be present when business is being conducted. So 2008 is when these laws came to place about noticing meetings and having agendas. That's why there are very strict rules about what goes in the agenda, that you can only discuss matters that's in the agenda, and that you have to notice meetings. If it's a regular open board meeting, it's 4 days in advance. If it's an executive closed session, you need 2 days. There are certain exceptions to this basic rule, which we'll talk about. So the main point of the Open Meeting Act is that boards can't conduct business outside of a noticed meeting for which an agenda is provided. So only matters in the agenda that is part of the meeting notice can be discussed in meetings. Let me just go back a little bit. The agenda, it's important, even though they are very general items. Sometimes it's just, approving landscape contract. Sometimes it's so general, and that's okay. And sometimes it's too general. The point of the agenda is to make sure members are aware of just in general what's going on. So for example, if approving, if the board will be discussing an architectural application, you would want at the very least the address of that application and just a general description of what is being discussed, so that people who care about that can decide whether or not they want to attend the meeting where that will be discussed. But if you just put something so general like review of architectural applications submitted, people won't know which applications and for what types of modifications those applications are for. So just something to keep in mind. Exceptions to that basic rule of only discussing what's in the agenda for the meeting. That's if you are going to briefly respond to statements or questions from members. asking when they ask for clarifying questions during the meeting and you want to just respond to that, that's okay. You don't have to say, I can't answer that because it's not in the agenda if it's clarification or responding to their basic statements and questions. Brief announcements, the code says you can do that even if it's not specifically on the agenda. And then when you do your manager's report on things that are pending, and these are just usually updates of things that probably were in prior meeting minutes, that's okay to discuss in the board meeting, even if not specifically described in the agenda. Boards can refer to informational matters and administrative tasks to the managers and staff. So when you're being given directions from the board during meetings, that's okay, even if not specifically listed in the agenda. And then other exceptions, if there's an emergency and there has to be a declaration that you're dealing with an emergency. Sometimes it's so obvious that you're dealing with an emergency, but sometimes it's gray. And my general rule of thumb is this something that can be discussed in 4 days? Is there time to notice a meeting, or is this something like sometimes when we're in litigation, we're given, a certain number of days to respond to a settlement offer. So we don't have time to notice a meeting. So that might be an emergency. Or sometimes you're dealing with a leak repair or a fire repair, and you don't have 4 days to call the board to a meeting and make that decision. So that can be dealt with outside of that noticed board meeting. If something came up after you've noticed a meeting and then the meeting, like these situations, then at that meeting, they can discuss that item, even though it's not on the agenda because it's something that came about. And that's something the code has requirements like if there's an emergency, then a majority of the board present can declare that an emergency and discuss it. And then if it's an immediate action, 2/3 of the board can vote to discuss that item. And then something that was previously in an agenda for the prior meeting, but it gets carried over, that can be discussed at that meeting, even though it's not specifically, in that agenda. So that's a lot. Types of meetings. So I'm going to hold questions till the very end. If you want to type it in the comments or just jot it to yourself. I'm not good at reading comments while talking. I think that would be the easiest. But if something doesn't make sense and you just let me know immediately so I can clarify it quickly. Types of meetings to keep in mind, there are several, although most of your meetings are probably regular board meetings and regular executive meetings. Annual meeting of the members, that's some I guess a lot of associations have them. It's typically when they hold their board elections every year. Some associations are required to have them. You would want to check your bylaws, and some we've been updating bylaws and restating them and removing that requirement and making it optional, because technically the elections can be conducted at an open board meeting. So you only need a quorum of the board to open up that meeting and not a quorum of the members, which is sometimes hard to obtain. So annual meeting of the members, typically that's where the elections happen. It's once a year. Sometimes it's just a social gathering or where the board updates the membership. The annual meeting of the board is usually, it's the meeting that happens right after that. If they just had their election, it's usually the meeting that happens where they elect officers, and probably nothing much because they haven't had time to prep or have a board packet reviewed. So there may or may not be an annual meeting of the board. So regular meetings of the board, that's what we talked about. This is the meeting that's open to members and requires 4 days notice and an agenda. And then this, I'm going to skip executive session meetings of the board. This is closed to members. It's usually before their regular open meeting, sometimes after, sometimes both. That also requires notice. It only requires 2 days notice. And there are only 5 categories of the subject matters that can be discussed in the closed session. Special meeting of the members right above that. That's when the members call a special meeting, and it requires a petition from at least 5% of the owners. Usually you will see that as a petition for a special meeting to recall a director. That's the most common one. But I have seen members try to notice special meetings to for all sorts of things, to discuss the association's finances, to discuss decisions made by the board. I have seen one where they wanted to call a special meeting to terminate the management company, but that was not noticed at my direction because it's not something members have authority to do. It's a board decision to hire or fire management. But typically, if it's just to discuss items, they can do that. The association is required, or the association should notice it, because if they don't notice the special meeting, then those members who petition can, and then you would not have control of that. So anyway, if you get a petition for a special meeting, regardless of what it's for, whether it's for a recall or some other issue, get counsel involved, because there are strict deadlines to get that meeting noticed. Otherwise, you have no control over that process. And if it's for a recall, the association is required to mail out ballots, even if it doesn't notice the meeting. Emergency meetings we talked about. There's notice is not required. You would still note the decisions made at the emergency meetings at the next open board meeting minutes. So it's something where it's still documented what decisions are made, but you don't have to have prior notice and an agenda for that. Let's go back to that. Emergency meetings. So that can be called, that could be by conference call, by Zoom. You can take action by having the board vote for that, or you can also obtain unanimous written consent when there's an emergency from the board. Maybe some of you have done that. That's when you get everyone to respond in writing and agree. Usually it's for non-controversial things, but if it's an emergency and it's controversial, or not everybody agrees, then you want to call a meeting either by conference call or Zoom so that you can take a vote, since if you're not likely to get unanimous written consent. Okay. So that's that part. Board member communications. We always, as part of our general training, we always tell them to avoid having a lot of discussions with members outside of meetings with homeowners, and to direct those homeowners to management, who can then compile all that information and then put it in the board packet or distribute it among all the boards, so everybody's on the same page. But if you have board members, trying to conduct association business in the hallways, and then they forget to tell you something, those promises being made, even though it's by an individual who probably doesn't even have authority to make those promises, there's this confusion of what the association is on the hook for and what they're supposed to do. So remind board members to not communicate with their members outside of meetings, which I know is very hard, but get them in the practice of that. Also, board members with each other should avoid having those discussions. Sometimes it's hard to, and I know some managers don't purposely don't copy all the board members in an email because some can't help themselves and like to have discussions with each other over email, which should be avoided as much as possible, although I know difficult. Other than logistics, setting up a meeting, adding agenda items, there should not be email discussions with board members about, debating association business. That shouldn't be done. All of this, remind boards, but also all of this, it's helpful if it's in an ethics policy or sometimes we call code of conduct, to remind them, and something that you can point to and make sure that they're complying with these rules, because it's probably, this is the part where board members are not comfortable with this, because they think if they have to wait every month or every 3 months to talk to each other about association business, nothing will get done. But you have to remind them the Open Meeting Act is there. And yes, it's kind of like red tape, but it exists because the laws want to protect homeowners from things happening behind the scenes without them knowing. So it's important. Okay. So definitely, if you get wind of board members, and a lot of times they mean well, and I try to tell this nicely, a lot of them are like to, they think they're being helpful by being responsive to homeowners by email, but later on that could just hurt the association more. So please discourage that. Tell them they're not supposed to be doing that you will handle those things for them. And then if they don't listen, the most important thing is the exposure to personal liability. I mean, nobody wants to get sued and not be covered by the HOA's D&O policy. So, yeah, tell them to not do that. Okay, I'm going to jump into executive session meetings. I talked about how there are 5 different topics. These are the only topics that you can discuss in a closed session. Some of these are mandatory, some are optional. I and probably other law firms recommend that all of these should always be discussed in executive session. Because the way the code is worded, like member discipline, it says it should be in a closed session if the homeowner requests it. But we don't even want to wait for them to request it. It should just be in executive session. Although there's only 5 topics, litigation, for example, is interpreted broadly, not just by a firm, but just generally in the industry, to include all communications with counsel, even if you're just consulting, even if there's no pending litigation. Sometimes we, for communities where you have members that are sticklers and saying, why is this an executive session? There's no litigation. You want to put pending litigation. But I think it's undisputed that legal matters, when you're talking to counsel or discussing counsel's written opinion or advice to the board, that needs to be in a closed session, because that's attorney-client privilege. It's confidential, and discussing it in an open meeting is a waiver of that privilege. Managers are legal agents of the association, so you are included in that, the privileged communications. So meaning you can talk, and this is why our office can talk with you and it's still privileged and we're not disclosing it. You're not a third party, you're an agent of the association. But when we start talking to homeowners, that's not privileged, that's really discoverable. So, so let's see. Okay. So these are this is under the civil code, payment plans and disciplinary actions, personnel matters, hiring, firing, not happy with a vendor, management, fellow board members, that all goes under personnel matters. Of course, discipline is talking about disciplinary hearings, but even before you set a hearing and just talking about whether to even call someone to a hearing, that's a disciplinary matter that should be discussed in a closed session. Formation of contracts includes reviewing bids or talking about whether to sign a contract, going through council's comments about a particular contract, negotiating certain terms. Those types of discussions fall under that formation of contracts with third parties. Okay. As far as the key to effective and efficient board meetings is having a plan and preparing, and not just for you, but getting your boards prepared and encouraging them to come prepared to meetings, to read their board packet and not review a 10-page contract for the first time at the board meetings. And for you, it's part of your job so that you're not in a 5-hour meeting over association matters, is keeping them on track, and even in some situations timing the discussions. One way to do that is to discuss the controversial issues to the end, or if there's like a lot of debate, to move those things towards the end so that you get as much as you can done before you start having boards debate things and then they get in a bad mood and they don't want to handle even the easy stuff. And then ending with follow-up so that everybody knows what they're supposed to do and who's supposed to do what is important, because you don't want to end the meeting and you're like wondering what was supposed to be done by you or by council or by one of the board members. So always wrap it up with like reading the to-do list. I don't know if you have a term for that, but reading the list, the action items, I guess, is what you can call it. As far as preparing, I've seen I think it's helpful. I've seen managers have a set schedule, like you already have dates for your meetings for your regular meetings for the year, so that you're not checking calendars each time. That works for some, and I know it depends on the community and your type of board member. Some of them don't know their schedules until closer, but if you're able to get those dates already, that's helpful. And then at the very least, confirm at the end of the meeting, so you're not sending emails after about checking about everyone's availability. If everyone is in the habit of showing up to the meeting with their calendar, and at the very end, you're already setting the date for the next meeting, that's helpful for everyone. And then, taking note of deadlines for items on the next agenda. Sometimes you discuss things like, yes, we need to get proposals for this. We need to do this. But you don't sometimes forget to ask for a deadline, because sometimes there's a certain time frame that something's needed. So it's good to have that clarified when you're going through kind of the action items, is when sometimes you need things sooner than the next meeting. And you also need to set the right expectations for your board members, because some of them think it's easy to get 3 proposals in a week, when it's not, because that means, for some vendors, you have to keep asking at least 3 times to get the proposal. So make sure they're aware of that. As far as the agenda, again, because of the Open Meeting Act, only items in the agenda can be discussed. Any board member can ask for agenda items to be added, but the president usually is tasked with helping tailor or organize the agenda items. And you, with your experience, can also help guide what needs to be discussed first versus last. Certain things just need to get done, like approving bills or invoices. There's certain things you need to do so that you're not in breach of contract. So the board is relying on you to help them organize their meeting. You can put committee reports, like I mentioned, sometimes it's just manager's report or architectural committee report. That's okay. But again, if the board is going to make a decision based on something that's reported by a committee, you'd want to do that where it's specified in the agenda. So the architectural committee, for example, can say, yes, we received this 5 applications this month. It's for these types of items. The board will need to set a separate meeting where that's on the agenda on the particular item when they are going to decide to approve or deny the application. Homeowners sometimes may contact you and say, please add this to the agenda next. I want the board to discuss this issue affecting my home. You don't have to tell them, just say, yes, I'll forward your request to the board. You don't have to say you as a homeowner don't get to add items to the agenda, but because that's true. But the board can make that decision. So forward those comments and inquiries to the board, and they can decide whether they want to add that. But they should be aware, of the issues raised by homeowners. So agenda items should be emailed to you. And I strongly recommend that you tell your boards, give them a deadline so that they're not emailing you changes like 2 hours before the meeting, so that they have reasonable expectations that you need to, they can't be doing that anyway because you need notice of it, but you don't want it last minute, right when you have to post it. Okay. And then prioritizing, we talked about that. Okay, the board packet. I think it's helpful when the board packet is organized in the same order as the agenda. Of course, it doesn't have to be, and sometimes you get things last minute, but that's helpful when you're going through the meeting, that you're flipping through the board packet in the same order as the agenda. Encourage your boards to read their packet in advance, just so that the meetings can go quickly. And if you probably have in your contract that you charge for additional time, any meeting after 2 hours, some boards probably need to be reminded of that. If they are being inefficient. Sometimes it's just needed and that's why it's there. But if they're just being inefficient with their time and unorganized, then you need to push them to be prepared. Same thing, and part of being prepared is making sure that they have their list of questions and concerns ready for the meeting. And again, not using the meeting to review lengthy, complicated documents like contracts. They should already have their comments ready to go. Okay, so keeping the meeting on track, follow the agenda. If you have a nice, neat agenda in good order, then you can use that as a guide, and you don't have to spend time moving things around. I like agendas that have a time slots, although you don't have to stick strictly to it, but it gives you a tool to say, okay, it's already 7:45 and we're still on item 3 and that's supposed to be discussed at 7:30, so we need to move things along quickly. That's helpful. It's a pain to put that and kind of get, when you're preparing the agenda, but it's helpful for your boards that need a little push to keep things going. Remind boards to only take action on items that are on the agenda. Again, it's not because it's you, it's because of the Open Meeting Act. And then we talked about discussing the non-controversial items first. And then, and even if there's certain things that need to be discussed, if you're getting the sense that this board needs to have a more thorough debate about it, then, after 5 minutes of discussing, just table it for the end of the meeting so that you can move on to more items to check off on the agenda. Okay. Homeowners forum. So homeowners have the right to speak at board meetings, but it's not for every single item. Although I have seen some associations and corporations have homeowners forum for each agenda item. As you can imagine, that would make meetings very, very long if they get to speak their mind about every single item. And I have seen that actually where one homeowner just, even when he has barely anything to say, would just say, I would like to say, I agree with this. But that takes a long time. It could be, I think a more efficient way to do it is have the homeowners forum either before the agenda items or after. It depends on the community. Sometimes if you wait till after people have already left, or sometimes it's good when it's after the agenda items, because if you have it too early, some people are still coming home from work and nobody will be there. So it just depends. It is reasonable and totally acceptable to have time limits for homeowners forum for each person. So that is okay. I think anything between 2 and 5 minutes I have seen. So that is okay. I recommend putting that in your agenda so they know ahead of time, like it could be in your typical form. Maybe it is already, so that they're on notice that, they have a limited amount of time to speak. And then, for some boards that like to engage, I would remind them that it's not the time to have a debate or a conversation with homeowners about these issues. It is an opportunity for homeowners to be heard. And then whatever their concerns are, take note of it, encourage the board to add it to the agenda of the next meeting and discuss it if it's important. But it's not the time to debate or to have a contentious discussion with a homeowner about something. Communication style. So you all know there's sometimes I like to say, oh, where's that association from? I make these really broad assumptions about people, but we all know it's not. It just depends. But we all know they're, depending on their age and how long they've been on the board, maybe, there's certain things that can impact what kind of approach you need to be effective with them. So just be aware there's, there's not a one size fits all approach. And we all know, even if you tried your best, sometimes you need to bring in somebody else because a different personality works better with that type of board or that type of board member. So be mindful of that. Setting expectations, the right expectations in the beginning is important when you have new accounts or new boards, because especially now, it seems like a lot of boards, and they're doing this to council too. We have these new accounts and they're like, oh, our other law firm didn't do this, so we want you to do this. And it's impossible what they want. So same thing, you get new accounts and they complain about their prior management company, but what they want and need is really not realistic. So you have to tell them and make sure they're aware of that in advance, because we all know once we give in to those unreasonable expectations, they expect it each time. So, and it's not manageable if, we're dealing with a long-term relationship. So have that conversation early on. The board trainings we go through, we touch on this a little bit. But it's important they understand that if they are being managed by a portfolio manager and someone who's not dedicated to them full time, they need to understand that you have other associations you're committed to, and they can't just, call you and expect immediate things done for their association. Board members' opinions. Lately, it seems like everyone's very, very opinionated these days, which makes it so difficult. And everyone's like, just okay with openly expressing things that are sometimes not appropriate, but it's out there. And encourage board members to express their opinions and perspectives, but they need to get along to conduct. They need to have that professionality. They need to get things done. And sometimes that's more important than having board members that are highly educated or experienced. Having board members that are reasonable and willing to listen to other opinions, and then, everyone agrees to not agree on everything, but to move on and after they take a vote. That's really important in an association that's governed by a board of 3, 5, or 7 people with different backgrounds. So that's always a challenge, and that's always going to be your challenge. So ethics policy and a code of conduct, again, is really helpful for dealing with those types of boards. But in general, it's something we recommend for every single board, because you want to have that. You want to have that in place before you have a problem board member join the board. Virtual meetings. I'm not a fan of recording board meetings. So we're often asked, can you record? And it's like, sure, you can. But see, when you have this recording, then everyone knows, and then members often expect that recording is available to them. So if you do record, I would let everybody know at the outset that it's being recorded simply for the preparation of meeting minutes, that it will be deleted after a certain number of days. And, the meeting minutes are available for members who want it, but not the recording. You just have no control of how that's going to be used or misused. So let board members know. I think these are kind of what you probably are doing, not having a comment section during meetings, because that's just disruptive. And hopefully we'll be talking more about this with the new laws that are being proposed for next year. There is a new bill that's being proposed, and to basically continue the Zoom meetings like how we've been doing it already. So the same rules would apply. You don't have to figure out the new laws, but just extending it regardless of whether there is a state of emergency or not. That's one bill to track. And then we talked about concluding with clear direction. It's helpful not just for your meeting minutes, but for your notes, for your manager's task items, to figure out what needs to be done and who's going to do what. At the very end, summarizing with the board that you're working with, the questions, concerns, and recommendations, and as far as the meeting minutes, boards have different expectations. Normally they are very general and just have minimal discussion of what those items are. They don't need to be detailed, but we all know some boards want them detailed. So you have to just explain, or you can have counsel help explain why. Sometimes it can hurt them having too much detail in their meeting minutes. And then, that open board meeting minutes, those are subject to review by the membership, but not executive meeting minutes. So those are confidential and not subject to production. Okay, we talked about all this, setting expectations and follow-up items. So the key summary of what we discussed, making sure your board is prepared, and just running the meeting, sticking to time limits and agenda items, just being, meetings, you really have to be the leader of that, the whole process. Because if you don't, meetings can be long, things can, you end up with a very long meeting where nothing got done. And that's a nightmare, the nightmare situation. So for those that are newer, you have a lot of resources available to you, including very experienced managers in your team, but I'm sure have more tips about running an efficient and effective meeting than what I just put up here. Definitely refer to that. But as far as legal is concerned, it's the Open Meeting Act, all of that. That's really important for being familiar with, and at least if you have questions about what needs to be on the notice or agenda, that's where you need to go to in the Civil Code, is that portion, the Open Meeting Act. So with that, I'll open it up. Questions, comments? Roman.
All right. The thing that spoke out to me the most that I want to know about is that whole section about board members bringing up items that are not on the agenda and have to be voted on. Is that a rule? Is that a law? Can I please impose this? Because the biggest problem I've been having recently is board members will go, okay, let's just, what about this thing? And then they just start talking and I'm like, okay, let me just write this down, I guess. But if I can go, hey, no, we can't talk about this. Here's a law. Here's a rule. Then, I did not know about this. I cannot wait to make them shush.
Yeah, so you would want to pull up the Civil Code section, Open Meeting Act. There's a part on there about only discussing items on the agenda. Just say, hey, this is not on the agenda. Let's go put this down and add it to the agenda of the next meeting so that you can do that.
Okay.
Unless it's, there's exceptions, unless it's an emergency. But if it's something spontaneously, they just decided, we need this. It's, that they're leaning to you. And if a homeowner complains like, what the heck is this thing that's like, $50,000 that was approved, I didn't know we were going to do this. They're going to blame you, because they're like, we didn't know we were supposed to have that on the agenda. Why didn't you put it in the agenda? And then you have to remind them, like, remember, you discussed that last minute. So that's an important thing. And it's this Open Meeting Act that you might want to just all grab, like this section of the Civil Code and just hand it to them, like, hey guys, just want to remind everybody, read these code sections. So we just say, we need to do a better job about only discussing. I know it hasn't been an issue. You don't have any members complaining, but you never know when somebody's just going to decide to nitpick at everything the board is doing. So that's an important one.
Wonderful. Thank you.
Yeah. Tanisha.
Okay, so I'm going to be attending my first meeting next week. And there were a couple of items that weren't necessarily on the agenda, but came up literally like the moment I wrote the agenda, sent it out. So is it okay to bring that up? Like, because we're kind of telling these homeowners, like, well, we are talking about that already, so we'll add it to the agenda, sort of like verbally. Is that okay if it's like already an agenda item and we're just adding 2 more people to this discussion, like about parking or whatever?
Yeah, I mean, your agenda probably is so general that it has parking issues. Right? It does. Yeah, and then when the item gets discussed, that's any recent emails or complaints or whatever it is, even if it's after the agenda was posted, that's still that can be part of the conversation. Okay. Because members, the idea is just think about if you are a member and you cared about parking and you showed up to the meeting, did you get enough notice? Yeah, it's about you knew the board was going to talk about parking issues. So it's not just stuff and complaints that were received when the agenda was posted. It's about that whole topic. Okay. Yeah.
And can you send these slides?
I think so. I think we send them. Let me ask. But yes, I think so. I think we do. We don't normally, if you've been in any of our board trainings and stuff, we normally don't circulate our PowerPoint, but I think we do for these call-ins presentations. This is the first one, so it's probably fine. Good questions. Brad.
Hey, and a couple quick questions for you. Question one is, how should we handle or how should we address the boards that want to put a miscellaneous topic on their agendas under new business as a catch-all for things that weren't listed in the on the agenda?
I'm okay with putting a catch-all. I would make it more detailed than like other, other or something like could be like other parking issues or other. I think it's fine. But anytime they're about to approve something that could potentially be something people care about because it's a lot of money or it affects someone's property, you'd want to say, okay, yeah, I mean, after discussing it, just say, okay, at least for this portion where you approve this work, let's do that. Let's do that the next meeting, so that we make sure we're in compliance with the Open Meeting Act. In case someone decides to challenge it because they don't like it. So that's why I'm kind of flexible with the let's discuss these, and it's part of this broad catch-all category. But when it comes to decisions, anything with money, anything affecting, what people see and how they use their property, then I like to be more protected and not just say, yeah, architectural applications were in there. That's when we approve this whole big thing. Because I dealt with that where I had to make an argument that's saying, yeah, no, architectural committee reports were in the agenda. And this one homeowner's like, I didn't know they were going to build this thing. My neighbor was going to build this thing. Otherwise, I would have showed up. And she's an attorney, and she likes to challenge us a lot with a lot of things. So I'm like, this is not one where we can get away with some kind of generic category. So I told them to, I made the arguments like, it's there and whatever. But I said, okay, let's discuss it at the next meeting, and you can confirm your decision to approve that application at that meeting.
Okay.
And of course, she showed up and got a chance to say, I don't like it. And then it was still approved. So.
Okay, and then my second question is, once the agenda has been created and published, distributed to the homeowners, posted, wherever you want to call it, what if the board says, you know what, we want to add an additional topic? We still have 2 or 3 days before the meeting. Can we amend the agenda if the meeting is still being held at the same time and place?
Can it be considered an emergency? Because if not, then that's too late for that agenda, because you can amend it, but then members need at least 4 days for an open board meeting to see it there and then decide if they're going to show up or not. So if you amend it and it's not an emergency, then it technically can't be discussed, or that decision can't be made at that meeting because members didn't get enough notice. So
Gotcha.
But if it's an emergency, you don't even have to amend the agenda. You just you can discuss it.
Well, I mean, for example, as you were talking about architectural applications, on my agendas, they have a spot on the agenda and it reviews every one that's going to be reviewed and approved, or reviewed and decided upon in the agenda. And if somebody says, oh, I want to get my architectural application in right now, so it's on the agenda, can we amend it to add their application to the agenda without a full 4 days notice?
Yeah.
Yeah, that's what they're trying to. Anyways, all right, that's cool.
Technically, no. Technically, no. But if they did, could they get away with it? Maybe.
Right.
But yeah, no, it's, yeah.
Okay, thank you.
I see any other hands raised. Did I get everybody? Okay, cool. Any other questions or weird situations you're dealing with at a meeting or in general? I'll open it up to anything. We don't have to talk about just meetings if you happen to have an issue that you're dealing with. No.
No, I think the purpose was just more of the basic information, and I think you really covered it really well, Anne. Thank you so much.
Yeah, no, you're welcome. So yeah, so I think the point of this, take a look at the Open Meeting Act, copy and paste that section, send it to your boards, maybe as a refresher, as a reminder, or new clients that really need it, have it handy, so you don't look like the bad guy. Actually, you're the hero trying to save them from an Open Meeting Act violation. So good luck to those going to your first meetings. Hope that goes well. I'm sure you're well prepared by Collins and your management team. So good luck, and let us know if there's any issues or questions, other legal things that you need us to jump on.
Thank you, Anne.
Bye, everybody.
Thanks, Ann. Bye.
Bye.